Sometimes we have to look at non-Second Amendment cases to learn about the Second Amendment. And that's the case with today's Supreme Court case that was just decided, the Consumer Financial Protection Bureau case involving the meaning of the constitutional text dealing with appropriations. Yes, appropriations, which means the spending of money by federal agencies. Guess what? The U.S. Supreme Court used text and history to interpret the word appropriations, but we have to talk about the similarities and the dissimilarities between what the Supreme Court did with interpreting the Appropriations Clause as it was written at the time of our founding with, let's say, the Second Amendment adopted in 1791. Stay tuned. We're going to get super geeky on this constitutional question involving the Supreme Court decision of the Consumer Financial Protection Bureau case. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed, What the 10/7 Terrorist Attacks Teach Americans About the Right to Bear Arms. A lot of critical history there, a lot of critical lessons there for we here in America to learn from the mistakes the Israelis made by not allowing, in the robust way, armed citizenry. Check out that book on Amazon, Israel Disarmed. You'll enjoy it. A lot about the Second Amendment in that book. All right, folks, so here's the story. The U.S. Supreme Court decided a case called the Consumer Financial Protection Bureau, CFPB versus Community Financial Services Association of America. The reason why we're talking about this case, even though it doesn't directly relate to the Second Amendment, is because the methodology of interpreting the Constitution adopted by the Supreme Court in this CFPB case is very similar to what they use in Second Amendment cases. But there's some key distinctions that I want you to be aware of so you're the smartest person in the room and this cannot be used against you. Specifically, just as a reminder, as an overview before we dig into the facts of this case and the interpretive methodology the court adopted in interpreting the Constitution, we must remember two things. The Constitution has sort of two overarching things going on here. One is, obviously, the ultimate goal is to make sure we're protected from foreign invasions and we have an operative national government. But at the same time, we want to make sure our fundamental rights are protected. So the two things going on with the Constitution of the United States, of course, is you're trying to protect individual rights. That's why, among other things, we have the Bill of Rights, which includes the Second Amendment right to keep and bear arms, in addition to things like the First Amendment right to free speech and the right to free press and so on and so on. So always remember you do have a rights protecting component associated with the Constitution. But there is another important part that you must keep in mind. That is, it sets aside and describes and articulates powers, governmental powers. So once you understand that there's rights and then governmental powers, but they're all related to the same concept. What did the founders think when they were writing the Second Amendment? What did the words mean? And that's exactly what the Supreme Court did when they interpreted the CFPB case, the question of what is an appropriation. Here's essentially what the case was about, just so you're aware of it. Then we're going to dig in to the methodology of interpreting the Constitution that the court applied in this case. And you will see similarities as to how they interpret the appropriations words in the Constitution with how they interpret the Second Amendment. But there's going to be some key differences we're going to talk about at the end that I don't want you to be tripped up on if anyone pushes back on this, because you are the smartest person in the room, and that includes even if you have elite, liberal, Ivy League professors and all that good stuff. I'll make you smarter than they are. That's the goal. So let's turn to the case, CFPB, and see what it was all about. The Supreme Court wrote, the Constitution gives Congress control over the public fisc, subject to the command that no money shall be drawn from the Treasury, but in consequence of appropriations made by law. That's the key language. In consequence of appropriations made by law. For most agencies, Congress provides funding through annual appropriations. For the Consumer Financial Protection Bureau, however, Congress provided a standing source of funding outside the ordinary annual appropriations process. Specifically, Congress authorized the Bureau to draw from the Federal Reserve System an amount that its director deems reasonably necessary to carry out the Bureau's duties, subject only to inflation-adjusted caps. Now, in this case, several trade associations sued to challenge the lawfulness of these appropriations. And what did the Supreme Court hold? The Supreme Court actually held that looking at the time of the founding, the word appropriations meant that Congress actually directed something to be funded. And it didn't have to be directly, let's say, from taxpayers or tariffs. It could be funded in different ways. And then the court went on to basically say that in this case, the Consumer Financial Protection Bureau has been funded in a way that was directed by Congress. And because Congress, in its statutory authority, said this is okay, that is consistent with how governmental powers functioned at the time of the founding or in the early American Republic. So that's what's very important here. Now, big picture, before we get into some of these specific details, remember that the Second Amendment and the Bill of Rights was about what? It was about codifying or memorialization of rights that existed, that pre-existed the Constitution itself. That's very important because, in contrast, the federal government set up by the United States Constitution in many respects was sort of brand new. It was a new concept created at the Constitutional Convention. Do you see the difference? So while the Bill of Rights deals with pre-existing rights that existed before the Constitution, many aspects of the Constitution's parts dealing with governmental powers, governmental authority, the ability of Congress or the government, the federal government or the courts to act in a particular way, that was somewhat new. The reason why this is important is when you're dealing with governmental powers of a new constitution, of a newly formed government that had never existed beforehand, that is important because sometimes events that occur after the creation of the government can be more relevant and insightful as to what the founders thought the government was allowed to do or not do, which is different than when you're codifying a pre-existing right. So this is important here because in this case involving CFPB, the Supreme Court looked at many activities that occurred with our federal government after the creation of the federal government. And they put a lot of weight on that because, again, unlike the codification of pre-existing rights that had existed in America from decades, if not hundreds of years before the founding of the United States and the creation of the Constitution, the new government was new and needed to. So therefore, the Supreme Court, looking back at the CFPB case, they put greater weight on what happened after the adoption of the Constitution than they would in the context of interpreting a fundamental Bill of Rights provision like the Second Amendment. Now, let's just talk about a couple things. First of all, of course, as an originalist, which is what this court is, which is why we have to talk about the notion of originalism. And originalism is basically just being, you're a lawyer doing what lawyers do, which is you go back to the creation of a contract and you try to understand what did the parties intend when they wrote the contract, what did those words mean, and what were people trying to deal with the contract, and that is what the Constitution is viewed as. In 1791, when the Bill of Rights, including the Second Amendment, was adopted, what were the founders trying to protect? Likewise, when they created the federal government, what were they trying to create? What was the intent of the founders at the time of the founding? And we just glean intent from the language used, obviously, because the best historical evidence of what the founders thought is what they wrote down in the actual Constitution and Bill of Rights that was actually adopted. That's the ultimate historical text. That's the ultimate history that supports our right to keep and bear arms among other things. But then you can look at other extrinsic history to sort of buffer or give you some additional clarification on what that means. Well, the text at issue is really straightforward. What the text of the Constitution says is as follows: no money shall be drawn from the Treasury, but in consequence of appropriations made by law, which means that the textual question is, guess what? What exactly is an appropriation? Well, what the court did here is they start off with looking at the meaning of appropriation by checking out, guess what? Dictionaries that were used by the founders at the time of the founding. And guess who is one of the people they consulted with? I bet you're going to guess correctly, and that is Samuel Johnson. Samuel Johnson, who's the same man the British lexicographer, which means the creator of dictionaries, Samuel Johnson, the same guy that the U.S. Supreme Court used on multiple occasions in, for example, the Heller case to define the terms of the Second Amendment, is the same guy they turned to try to understand what did the Founding Fathers mean when they wrote the word appropriation or appropriations into the text of the Constitution. So the Supreme Court said the following about Samuel Johnson's definition of the word appropriation. At the time the Constitution was ratified, appropriation meant the act of sequestering or assigning to a particular use or person in exclusion of all others. They cite to Noah Webster, right? And, of course, to Samuel Johnson. Guess what? Both Noah Webster and Samuel Johnson make an appearance in that famous case in 2008 of District of Columbia versus Heller. Do you see how this comes back around? Do you see how when you learn about founding era dictionaries and you're like, Mark, why are you making me learn about the word lexicography? Why are you torturing me with dictionaries? What is going on here? It's because what I teach you back then comes back to the fore. And here we have Samuel Johnson, the British lexicographer, and the American lexicographer, Noah Webster, make an appearance in yet another Supreme Court decision. Do you see how this all works? So yes, they're using the same dictionaries used in the context of the Second Amendment to interpret the word appropriation in the context of what appropriation means in terms of funding government today. Now, with that said, let's turn to another big question we have. We understand the text, how they use the text, founding era dictionaries, but let's turn, and this is important, how the court used the tradition of governmental functions, the experience and traditions of government functioning. And this is where I want you to really be careful. Do not allow what I'm about to say to be used against us in the Second Amendment context, because it should not. The fact is that the Supreme Court in this case, and I'll read you the language, is talking about how Congress and government functioned after the creation of government. But again, the key distinction is that government, the American government, had never existed before. So therefore, they're trying to look at how the government actually was set up and used in those first few decades to try to understand the meaning of these words, which is in contrast, again, to the Bill of Rights, which was codifying existing rights. And thus, you can't look at subsequent history to narrow the scope or infringe upon the meaning of those codified pre-existing Bill of Rights. But you can look to subsequent history to understand what the founders thought about the powers and role of government and the experience. And here's exactly what the court wrote about this exact point. The way our government has actually worked over our entire experience provides another reason to uphold Congress's decision about how to fund the CFPB. You hear that language? The court is essentially saying that looking at the experience of how government runs teaches us about whether or not appropriations means other ways to fund the government versus like taxation, tariffs, or whatnot, or some appropriation from Congress itself. Won't get into the details of the case. It's not worth it. I'll put a link to it down below if you want to check out the specific dirty details of the case. But the bottom line is to understand that the methodology the court used to interpret appropriations is very similar to the Second Amendment, with that key distinction of drawing that distinction between pre-existing fundamental rights on the one hand and governmental powers that are brand new with a new government on the other hand. As long as you understand that key distinction, that will go a long way if somebody tries to use a case like this against us, because they should not be doing it, because they're different things. There's apples and oranges. Protecting rights, pre-existing rights versus new government never existed. Thus, the early American practices involving that government is fine to look at in a way that you wouldn't do when it comes to our rights. So there you have it, folks. I hope this wasn't too geeky, but again, I'm trying to connect dots so you can see how the current Supreme Court is thinking about these cases, and you can see how it all comes together in some sort of a gestalt of constitutional law. And this court, I truly believe, is trying to restore the Constitution, restore Second Amendment rights as to where it never should have left. It's taken a long time, in part because these are hard cases and there's a lot of work to be done. Certainly, I would like the Supreme Court to be taking on more cases on the merits. I understand why they think they can't or why they think it's too much. Nevertheless, you know my view on this. But with that said, we want to learn about the Supreme Court, how they're thinking about issues, including the Second Amendment, not just by reading Second Amendment cases, but also by taking a look at these other cases. This term alone, not only does a CFPB case teach us about how they think about founding era history and draw distinctions between rights and powers, powers. We also looked at the U.S. versus Brown case a couple weeks ago that teaches us about how they're likely going to conclude that, for example, drug traffickers and drug dealers are probably going to fall on the spectrum being violent people that can be disarmed, which is different potentially from drug users who are not violent, perhaps may not be disarmed. We'll have to see when the Rahimi case comes out and what they say, and of course, subsequent litigation and jurisprudence that arises from all of that. All right, folks, hope you learned a little bit something today. Hope it wasn't too geeky. Don't forget to follow me on X at 4Box Diner, and don't forget to subscribe and resubscribe. Make sure you don't get knocked off this list here on YouTube. And again, we'll see you again soon here at the 4Box Diner.
Orders up. Table 2A.